Thank you, ladies and gentlemen, for waiting for us there. There's a number of things I want to say. I'll be brief. The first and perhaps the most important thing is to tell you that there will be an appeal instituted against the judgment that was delivered by Justice Hughes this morning. That's the first point. It's the most important thing I'm saying this morning. But the other thing that's important for the wider South Australian public to think very carefully about and to remember is that our application is yet to be determined on its merits. Those words, or words very similar to them, are in Her Honour's own judgment. This was no decision about the strength or otherwise of our application. We say it was always a strong and meritorious and legally sound application. The application hasn't been determined. Hearing of our application has ended because the state government in May of this year brought in legislation which I say was designed to close these proceedings down. So these proceedings haven't been judicially determined, they've been closed down by the South Australian Parliament and the Malinauskas government, continuing with the same policies, the same disastrous policies in relation to vaccine mandates that the Marshall government instituted. So I think that's very important for anyone hearing of the outcome of this morning's application to bear in mind. All of the arguments we put, all of the evidence that was given, and you'll recall the expert evidence of Professor Petrovsky, none of that's been the subject of any judicial determination. Now, you may recall also that we asked the judge to send this question of the validity or otherwise of the state legislation. We asked the judge to send it to the Court of Appeal. You'll remember that. She declined to do that. We asked because obvious reasons in relation to expense. This is publicly funded litigation. But also because the legal issues involved in this are so novel. And again, you've only got to go to the judge's own judgment to see that Her Honour recognised that the authorities on the legal propositions that were involved in this application the Crown made on the strength of Mr Malinauskas' bill, the legal authorities don't really bear on it. We're into uncharted water here when the Parliament determines that they'll put important public litigation, carefully argued, strenuously argued, they'll put important public litigation beyond the reach of the courts. Now, I'd ask everyone to think about the significance of that. In the middle of the litigation, before it's concluded, the Parliament determines to close this important litigation down. Now, can I suggest that every member of the South Australian public outside of SA Health perhaps would know that the vaccine mandates as of September of 2022 have no legal justification. They've got no medical justification. The world outside of SA Health knows that workplace mandatory vaccination is completely ineffective at preventing the transmission of this disease. So, with those matters, with those important matters, I ask you to bear in mind it perhaps is also worth making some observation on how it came about that the Parliament had the opportunity in May to pass this bill, because you may recall we instituted these proceedings in December of last year. We didn't get down to the hearing of the application itself until April. So that 5-month delay was itself critical in giving the Parliament the opportunity to deprive the court, to this point at least, of the opportunity to determine our application. Now, the reasons for that, again, those of you who've been present throughout the proceedings will remember the interminable adjournments that were sought and obtained because of Ms Spurrier's perverse close contact and quarantine requirements. We had Crown Counsel unable to come along to court. We had our counsel unable to come along to court either because they had tested positive or a member of their family had tested positive, We had the judge unable to come to court. We had one of the judge's children unable to come to court. And then on top of that, of course, the police commissioner, who was a vital part of this application, and our cross-examination of him was a vital part of these proceedings, and he couldn't come to court because he contracted the flu. So all of these very unusual circumstances came together to provide the Malinauskas government with the opportunity 5 months after we got these proceedings running, when we were ready, able and very keen to put all of our arguments in detail and to have them ruled upon by the court. We weren't given that opportunity because of these delays, and that delay has occasioned this piece of legislation which the Crown have seized upon and which has resulted in these orders that the court have made today. But I'd say to the broader members of the South Australian public, keep your spirits up. We're still in this fight. We know the importance of the fight, and we're sure many, many of you out there know the importance of the fight. This problem's coming back. We all know that. We're not going away, and we will pursue our remedy in the Court of Appeal.
Still, Lindsay, this must be a significant blow to your team, to Denny.
Well, not in terms of diminishing any part of our resolve or their resolve, and I can speak for everyone, both the legal team and the litigants. Not at all. We knew, we were aware of these consequences in respect of the delay of the proceedings. We knew that the Crown would seek to take advantage of this legislation that's been drawn to give them the opportunity of closing the proceedings down. So it's not surprising. And to the extent it's not surprising, we were prepared for it, but it makes not one jot of difference to our resolve to see this through.
Where do you go from here?
To the Court of Appeal.